Good morning and welcome to the South Dakota Wage and Hour webinar. I'm Sean Lyons, Executive Director of the South Dakota Retailers Association. First, some information about our association. The South Dakota Retailers Association is a 3,900-member statewide association. Our primary mission is to represent retailers in the legislative and regulatory process. In addition, we provide information, offer training for food service and alcohol licensees, and provide member services. Those include credit card processing, workers' compensation insurance, dental insurance, and data security. We also have an agreement with the Jackson Lewis labor law firm that allows our members to get answers to labor law questions from an employment law attorney. Now that you know a little bit about us, I'll introduce you to James Marsh, who is presenting today's program. James is the Director of the Division of Labor and Management for the South Dakota Department of Labor and Regulation. He's held that position since 1995. James is a graduate of the University of South Dakota Law School in 1986 and received his Bachelor of Arts from Dakota Wesleyan University in 1983. He has always been a great resource for our association when we have questions on state labor laws, and we appreciate his participation in today's program. Two notes before we start the presentation. First, the phones of all attendees are muted, so we won't be hearing background noises. Second, we'll have a question and answer period at the conclusion of the presentation. If you'd like to ask a question at any time, just go to the panel on the right side of your screen. You may need to click on the orange arrow to maximize the panel. Where it says type message here, type in your question and then click on send. At the conclusion of the presentation, I'll read the questions out loud and James will provide the answers. Now, we'll turn the presentation over to James Marsh. James, good morning.
Good morning, Sean. Thank you so much for the opportunity to be able to participate in this today, and to Donna for putting it together. Let's just dive into it right away. We'll be talking about the Fair Labor Standards Act laws in our state, touching on a little bit the matters of federal counterparts to those laws, and of course mainly giving you the opportunity to give questions. I'm not giving official legal advice in this presentation. You as employers out there are certainly welcome to make use of my information, but Marsh said won't help you when the legal papers start flying. So talk to your attorney if you need recommendations for action. I guess that's my grain of salt is my version of the legal disclaimer. There's only so far I can go with that. In any case, let's talk about state fair labor standards laws today. They mostly consist of the minimum wage, which we'll talk about in a minute, child labor laws, and just for the many calls we get, the fact that they say, well, this isn't fair, what's going on in the workplace. This isn't fair to me. That's not what a fair labor standards law implies. It's not really an unfair labor practice law either, because that's a very narrow thing, talking about collective bargaining. So the fact that something is or is not fair is really not relevant. It's more a matter of a term of art we use in minimum wage and child labor cases. The first step in, before we figure out whether or not how the laws work, we need to figure out who's covered by them. And the main question that comes up, especially lately, is with the matter of independent contractors versus employees. I won't give you any magic bullet to try to figure out who fits in that category and who doesn't, but the best thing we've come up with is my kind of common sense permutation that I've used for about 20 years that I call the hiccup test. For what it's worth, I ran it by the law school professor who did labor law at USD at the time, and she said, "Can I use that in my presentations?" And I said, "Yeah, go ahead, knock yourself out." And since, as I gather, it has now surfaced, and they don't call it the hiccup test, of course, they call it something more formal or technical, but this is how it works. If you were to fire a particular person, just sympathetically imagining, would they experience an economic hiccup, or would they go on like nothing happened? Allow me to explain. If I've got somebody working for me as a clerical support member, and They've been doing it for me for 20 years. They don't own anything in their office. They're not the PC they work at, the phone they use, the filing cabinets, et cetera, et cetera. About all they own is a picture of the grandkids on the shelf. You come in, you tell them, I'm sorry, we've had an economic downturn here, we got to let you go. They're probably going to experience something akin to a serious hiccup. They're going to say, whoa, you mean I'm out of a job? I'm unemployed? And they're going to say, yeah, I'm sorry, that's what happened. And basically their economic life stops at that point until they find something else, until they're able to go out there and find some other work. They're not going to be doing anything for a while. Very different from a plumber, for example, who comes to your house, starts working on your pipes, and you say, wow, it's very clear that you don't know one end of PVC from another. They do that, and you say, I'm sorry, this relationship has to end now. That person with their truck and their cards and their tools and whatnot is going to pack up, pop in the truck, go down the street, and inflict their special brand of misery on their next customer. So that person is not an employee. They're an independent contractor because they have experienced no hiccup. Their life hasn't stopped, economically speaking. Now, of course, the more sophisticated definition has been given to us from the United States Labor Department last July 15th. They call it measuring the dependence of alleged employees on the business with which they are connected. You can look that up. In fact, we've provided the United States Department of Labor document as a handout for this webinar. To go to your webinar control panel, you should see a handouts area about 2/3 of the way down. You can open this document and print it if you like. All right. Assuming we have people who are real employees, the minimum wage for them is $8.55 right now. Will be through the end of the year. It's figured by the pay period or the month if there isn't one. Now, it's a little different from the feds. They do that by the work week. But then their minimum wage is only $7.25 instead of $8.55 like us. The state minimum wage will go up January 1st, 2017, based on whatever changes have been to the Urban Consumer Price Index, minimum of a nickel, 5 cents. You can check our website, dlr.sd.gov, in late October for the new rate. And if we go by last year, it looks like it's going to be the minimum. I mean, the actual rate change would have been more like 2 cents. But because the law says you do it by a nickel at a time, then we upped it by 5 cents. And it'll never go down, by the way. But you figure it over the pay period. We get so many concerns saying, I didn't pay this person for an hour. Does it make any difference? What we do is take it as an average. Okay. So if a person works 20 hours in a week for their pay period, they've got a pay period that goes weekly, say. Then you would take a look at that 855, you'd multiply it by 20, and you'd say, if that person made that much money, 855 times 20 hours, they satisfied the minimum wage. All right. There are various exemptions. One is for youth. The opportunity wage for them right now is the same as the federal one, of $4.25 an hour. If you have somebody under 20, you can hire them on a one-time basis for up to 90 calendar days at $4.25. Now, by calendar days, we mean if you hired somebody, say, on July 1st at $4.25 who was under 20, you count down the calendar 90 days, and on the 91st day, you can no longer pay them $4.25, no matter how many days actually worked in the meantime. Now, there is a provision that's being proposed. It was actually passed through the legislature, but now it's up for referral for the youth minimum wage. That was set under the proposal at $7.50 for people under 18. The referendum petition suspended the operation of that bill for at least the election this November, and a general election will decide if the bill becomes effective or not. So if the voters pass it in November, the youth minimum wage, anybody under 18, will be $7.50. If they reject it, we will go back to $8.55 with inflation adjustments come January 1st. Just so you know, with the youth minimum wage as well, there's no inflation adjustment to that provision, so it'll stay at $7.50 unless somebody changes it. All right. Second exemption that's become quite topical lately is for seasonal employees. This was passed 2-3 years ago in the session. If a person, and this is similar to what the feds do too, if you're employed by an amusement or recreational establishment, organized camp, or religious, nonprofit educational conference center, you don't operate more than 7 months a calendar year, or the business grows 3 times as much in any 6 months over the preceding calendar year as it did the other 6 months, then you're qualified for an exemption. There is no minimum requirement for the wage, actually. So let's say that I've got somebody who operates a hunting lodge for 3 months out of the year and also operates it doing skiing or something else for 3 more. During those 6 months, this person earns or grosses $150,000 a year. The other 6 months, they earn 50, maybe because they rent out land or some such thing off the lodge. Since the $150,000 they made in those 6 months in which they're operating were higher, or 3 times higher than the $50,000 a month they made the rest of the year, or $50,000 total rather, they made the rest of the year, then this business qualifies as a seasonally exempt business, assuming it is truly amusement, recreational, organized camp. Questions come up a lot about if we're talking about a restaurant that only opens for part of the year. That isn't an amusement or recreational establishment, so that type of thing is not going to qualify. Okay, for tipped employees, I'm thinking this is probably a pretty hot topic for this group. The tipped employee minimum is 50% of the minimum wage, whatever it happens to be. Because it's $8.55 right now, technically the 50% of that is $4.27.5. But you're going to have the odd hour now and then. So what do you do with that half a cent? We're encouraging you to round it down. There is no law that specifies that, but because the tip credit is an exemption to the minimum wage, we're viewing it as you don't use it unless you clearly qualify for it. So if you have half a cent, just round it down to the nearest penny. Okay? The difference between that minimum wage and $8.55 or whatever the current minimum wage happens to be is made up in tips. Now, for a person to qualify as a tipped employee, they have to make at least $35 a month in tips. Both as to our minimum wage right now and as to this threshold, we're actually higher than the feds. That hasn't happened in my memory, but in any case, this $35 a month is actually a higher threshold than what the feds require. And it has to be something traditionally considered tipped. Okay? So if you have somebody who's a manager of a business, they're not traditionally tipped employees. So those kinds of people are not going to qualify for the tip credit, even if they receive tips now and then. Tip pooling is okay. You can get all your employees together, put all the tips in a jar, and call it good. But not with non-tipped employees, generally speaking. So if you have a cook in the back that doesn't get tips, waitress in the front that does, you cannot pool the tips for both those people and pay it out to everybody, because the whole tip pool is then bad. If you do that, then we don't allow any tip credit at all for anyone. Okay? And in that case, a person that gets tips, say as a waitress, they're going to get their $8.55 an hour, and they're going to get the tips on top. So you want to make sure that keep people out of the tip pool that aren't really tipped employees. Now, we accept the fact that there may be a Starbucks exception to that, where managers work the tables. We have a situation where they are actually actively going in right alongside other employees. They're working, drawing the tip for the work they do. Those kinds of folks can make the case that they're qualified for the tip credit, but pretty much everybody else doesn't get it. Okay, now once you've got the minimum wage figured out and who fits and who doesn't, then one of the major questions that comes up is, how do you figure the time? Okay, how do you figure how many hours or minutes are going to be included when you're averaging them to figure out that $8.55? Well, first of all, there's no pay deduction for a break under state rules until at least 20 continuous minutes have passed. So if a person takes 3 10-minute smoke breaks during the day, you don't get to deduct them 30 minutes for that time. For a lunch break, just to let you know, the feds are saying in their regulations that 30 minutes are required as a minimum for a lunch break. So until they get to that threshold, you don't cut their pay, period. And if they're actually engaged in duties during that break, for example, you tell them, well, watch the phone during your break. Phone rings, breaks off. Okay? Even if you don't allow them just to simply sit and do nothing, you can keep them on your premises. You can say, well, you're going to stay in this part of our business for that half an hour, 20 minutes, whatever it happens to be. But they can't be doing anything at all. They were being asked to do potentially anything at all for it to qualify as a break. Now, I can't imagine there's anybody listening today who has an issue over the fact that people show up early or show up late for work. Never heard of such a thing. You designate the time for people to show up at 8 o'clock, and for some reason they show up at 8:05 or 7:55 or some such thing. So what are you supposed to do with those people anyway? Well, first of all, we recommend that you figure time in 15-minute increments, rounded up or down to the employee's favor at 7.5 minutes. For example, if they show up 7.5 minutes early, you pay them for that extra 15 minutes. It's counted as 15 minutes of time. If they show up 6 minutes early, you pay them nothing. If they are 7.5, 8 minutes late, let's say, then they're paid nothing. If they're 7.5 minutes late, they round in their favor, so they get that 15 minutes included. Okay? Now, if they're regularly doing this, if they're showing up early, say 5 minutes early every day for the last 10 years, it may not be the greatest idea to just keep rounding them all the time and simply whacking that 5 minutes. The feds will not approve of that, and I think push came to shove, we wouldn't either. Now, given that, the magic follow-up question, I assume, is, well, geez, we tell people they're supposed to show up at 8 o'clock. They don't. Why should we have to pay them for more time or less if they show up late all the time? That doesn't seem quite right. We've set our expectation. Keep in mind, and if you get nothing else from this webinar, I encourage you to get this much. Whenever you make a rule for people, stick to it. Okay? You've got to make it stick. All right? If you tell somebody that you're requiring certain things for safety in the workplace, you've got to follow up and make sure they do it. If they show up early and you don't want them doing it, you've got to get tough. You've got to say, no, you are not allowed to show up 5 minutes early. If you do it, I'm going to dock your pay, A, and B, I'm not going to credit you for any additional time you might be working, and if you do it again, I'm probably going to have to take some disciplinary action against you. Cut it out. If you do that, then we come looking, or the feds come looking, and they want to know whether these extra times should count. They will understand, or should, that your expectations are very clear and you don't allow any exceptions. And then they might be able to give you the benefit of the doubt. All right, deductions. All the time we have people saying, I lent this person money, or they trashed my stuff, and I want to be able to take those kinds of things out of their check. Can I do that? Well, assuming a deduction takes an employee below $8.55, advances, that's really not cool most of the time. An advance of less than 30 days is okay. So let's say that you go ahead and pay somebody ahead of time, and they come back and you can want to say, well, now you have to pay me $8.55, and you essentially say, well, I did already, and we will allow you to make those kinds of advances as long as those periods are not more than 30 days. You may wonder why. It's because our laws say that you have to pay all the wages you're owed to people, that they're owed rather, within 30 days, or no later than 30 days after they're earned. So we can't credit you for anything further back. Okay. Voluntary deductions are not included in this, like Social Security and health insurance and pension plans and things like that. If they happen to take somebody below $8.55, we don't care about those. What we don't want is somebody saying, well, I lent you $1,000 6 months ago, and now I want my money back, so I'm going to take it out of your check. Well, if you end up doing that and you reduce that person below $8.55 during that pay period, totally unacceptable, violates the law. So you're not to say you can't collect the money. That's not the issue. The issue is how you collect it, because what you've done essentially is to become a judgment creditor without going through the steps necessary to collect the judgment, like piling a paper, summons a complaint, and going in and getting a garnishment and all those kinds of things. You just said, well, here's this money, I'm just going to take it. Well, the truth is, the way our courts look at it is wage paid, wage earned is the property of the employee, not yours. So if you start taking it out of their check, it's really not much different than stealing. Okay? So it's important that you not take people for those kinds of deductions below $8.55. All right. Now, as far as hours worked go again, let's talk about travel for a minute. I've got somebody driving on company business. As long as you're driving, pretty much it's work time, okay, if I require the trip. If I'm a passenger, I only get paid during normal working hours. So if my business day is 8 to 5, I'm out there in the car at 8 o'clock at night, that time is not going to be included. We don't include commuting in that for time paid, but going back and forth from a primary office to a job site and back is included. So if I'm on a construction crew and I show up at the office, say when I'm in Pierre, and it's necessary for me to travel to Faith, 80, 100 miles away to get to the work site, the time spent between Pierre and Faith on the clock. And what the time spent for me to get to work in Pierre is not. All right. Illegal deductions. Deductions for discipline, not okay. Damage to the employer's property, really not okay. But the flip side of what we talked about before about deductions is if the employee is left with at least $8.55 in their gross in their paycheck at the end of the day, we're not going to stop you from making those kinds of deductions. If you decide, as long as they're left with that money in their pocket, there isn't any minimum wage violation, so that's where we leave it. They may have some kind of private contractual right to be able to pursue that with you, but that's not something we enforce. All right, child labor. We'll just touch on that briefly. First of all, if you're 16 and above in our state, you're an adult. You can do whatever you want. Drive an explosives truck, okay? Whatever was required and whatever is permitted. Federal law extends protections for 16 and 17-year-olds to people engaged in hazardous work as they define them under the rules. So if you happen to be subject to federal law, you could plan on basically anybody under 18, you have to watch what they're doing. But for us, if they're not federally protected, if they're 16 and above, they can do anything. Under 16s are limited in when they can work, how long they can work, and what they can do. For state requirements, if you're under 16, you cannot work more than 4 hours a day on a school day, 20 hours a school week, and 8 hours and 40 hours in non-school days and weeks. Now, the legislature changed a little bit what is a school day and week in the last couple of years. They've said that we look at the individual educational program for the person to try to figure out what that means. Then what they're really focusing on is homeschooling there, okay? So if I'm working for somebody if I go to school, rather, at home 3 days a week, and that's my plan, then I'm only subject to these laws for those 3 days. If I go to school as part of a homeschooling plan in summer, then that's a school day for me. So you might be covered by these rules all year long. We just don't really know. It's very individual. Just know that if your business is covered by federal law, they don't go as far as to talk about homeschooling and that type of thing. They simply say, when you're based on the public school calendar, you have to work, you can work more than 3 hours a day and 18 hours in a school week if you're covered by the law and you're under 16. Okay? Can't work past 7 o'clock on a day preceding a school day or past 10 o'clock in the summer. Before 7 o'clock or after 9 o'clock are the limitations that are set by the federal law. Okay, but the main one I get the calls about is about hazardous work. When can this person do this or that? Okay. Now our state standard on that is actually really vague. Okay, it says no job that is dangerous to life, health, or morals can be performed by somebody under 16. You might think, what the heck is that? Okay, and we don't really know either, honestly. But the best test I'm able to give you is imagine 12 of your nearby friends or acquaintances sitting in a jury trying to figure out whether or not this job is dangerous for the 16-year-old. Okay, if the 12 of them think maybe, might be, it's probably best not to have them do it. In fact, this is the one instance in which I will tell you you shouldn't call us if you have questions. If you're thinking, you know what, I'm not sure if this job driving this explosives truck is good for somebody under 16. Maybe I should call. If you're wondering, hang up the phone. Why? Because if you're not sure, you can bet those 12 reasonable people like you sitting in the jury box aren't sure either. And if they're not, there's a chance they'll rule against you. So just don't go down the road in the first place. If you're questioning it, don't mess with it. Now, for what it's worth, the department gets guidance from the feds in terms of their hazardous work orders, which are regulations concerning work clear up to the age of 17. If they think something is hazardous, we think it's hazardous. So it's worth taking a look at the website that's listed for you on this slide and get an idea of what is covered by them under those rules. Okay. Now let's talk briefly about overtime. Okay, I say briefly because overtime is regulated by the feds, not by us. So we cannot speak authoritatively about how those rules work, but we get calls about them all the time, and there's some basic things. Essentially, USDOL has said, okay, you can talk about those sorts of miscellaneous things that are general and simple, but if you have specific questions, ask them. Prefer to be contacted at the regional office in Denver, and the phone number for you is available there. It's 866-487-9243. But we'll just touch on the real basics. First of all, overtime for over 40 hours a work week, at least time and a half. Okay? So again, the feds think in terms of work weeks, not pay periods like we do. So, and they're only required at overtime for actual working hours. Okay? Holidays, for example, don't count. You give somebody a paid day off of some kind for Christmas or whatever it is. Those hours are not included when you figure whether they made 40 hours in the work, 41 hours, say, in the work week. On the flip side, unless you're in some kind of healthcare occupation, averaging of hours over 2 or more weeks isn't allowed. So if a person worked 42 hours one week, 38 hours the next, and you pay them every 2 weeks, you don't get to put the two together, divide by 2, say, well, they worked 40 hours a week. No, the feds are not going to allow that. It's not a daily rate, but a weekly one. I get lots of calls saying, I had this person work 12 hours today. Do I have to pay him 4 hours of overtime because my usual work day is 8? No. We're taking a look at the work week, not anything else. The work week doesn't have to coincide with the calendar week. You can set that work week any way you want. It's your business. But just be consistent about it, okay? So if you start somebody on Wednesday and you consider their work week to start that day, roll it around to the next Wednesday for that person and make sure they are or are not getting the overtime they need. Okay, now there's an exemption. This is not federal talk. This is mine. It just helps me remember, but it's a neat little acronym I like to use for CAPESHs. Okay, this is one class of exemptions, but the one we get the most play about for what I call the white-collar exemptions, or I call it CAPESHs, because CAPESH is for computer professionals, administrative workers, professional workers, learned or artistic, executive, outside salespeople, or highly compensated people. Okay? For particulars, each of those exemptions is spelled out in agonizing detail at the website that's listed for you on the slide. But suffice to say, you have an option of not paying overtime to these people if they meet the standards. Now, all CAPESHs, with the exception of outside salespeople, have to currently make at least $455 a week. In other words, if you've got a lawyer working for you and they're only making $400 a week, even though they are professionals, even though you pay them on a salary, okay, you don't make it. You still got to pay them overtime, no matter how you pay them, whether it's by salary, the hour, or commission, or whatever. You haven't made the standard. Alternatively, for computer professionals, they can make $27.63 an hour and still qualify. Okay, and the big one to me is they have to be paid on a salary basis. Now, there's an old logic statement in school, that you learn when you go into logic class, and it says all collies are dogs, but not all dogs are collies. Okay? So I commonly get the question from people saying, I pay this person on a salary, and now I'm thinking about putting them on the hours. Is that going to be a problem? And the question is, to me, well, does it matter? Because if I'm not a white-collar person, you really don't do yourself any favors by paying them on a salary at all, okay? Because you have to have a salary basis for a white-collar person to qualify. But if they're not white-collar, it really doesn't have any impact one way or the other. You don't make somebody exempt from overtime by paying them a salary. On the other hand, if you have got somebody white-collar and you want them to be exempt, you have to pay them on a salary basis, okay? All collies have to be dogs. So, salary basis is a very complicated thing. A starting point for understanding how that works is a neat website with a fact sheet that the feds have provided. I encourage you to take a look at it. But to me, what we get the most calls about is in connection with partial days. Okay? Somebody is on a salary, and you decide, you base their salary on an 8-hour day. And about halfway through Friday, they decide they want to go home. So you make the mistake of cutting them 4 hours for the day. Bad choice, because you're treating them more like an hourly employee than a salaried employee. Now, it's not like if that person goes home, suddenly the feds are going to come busting in your door and say, wow, you messed up this 4-hour thing, so we're going to start making you pay all this overtime. But if you continually do it, if it's a regular habit of it, they're going to have a problem. So it's important that you either cover that extra time with some type of paid time off under a preset plan, or you just pay them a salary for the day and call it good. Okay. Now, I imagine what's gotten most of the excitement lately is the fact that the rules may change that we've just talked about. Okay, the big thing is the base amount. Remember, we just said that if a white-collar person gets paid on a salary basis and you pay them at least $455 a week, that they qualify for an overtime exemption. Now, what the feds are proposing and plan on introducing as effective sometime around, I believe, June, July, so the target date for that keeps moving, is to change that amount based on the 40th percentile of salaried workers' earnings nationwide. Okay, and it can guess the farther along they move that effective date for that rule, then that target for what is the 40th percentile will keep moving. Okay? But the rules originally listed $921 a week as being the threshold, and they're estimating that by July, August, somewhere in there, it's going to be more like $970 or $50,440 a year. So if I don't make that much and I'm a salaried employee, I'm no longer exempt from overtime. Doesn't matter what I do, business manager, administrative person, whatever. I don't qualify. Okay, so rule to the rise, keep your eyes on it. Okay, this is what I had for this morning. I wanted to make sure and leave plenty of time for questions because I figured there'd be a share. But for sure, if not, again, if I leave with nothing else, here's our contact page where you can call us, email us with questions about workers' comp, about human rights and employment discrimination, about Fair Labor Standards, or just anything related to general employment law. We can't give you legal advice per se. Remember that grain of salt rule we talked about earlier, but we can talk about anything connected with employment law in general terms, and certainly if the rules we enforce. All right, with that, I'll open her up for questions. What do we got?
Well, thank you, James. And again, as a reminder for all of you, if you have any questions, go to that panel where it says type your message here, send it, and we'll try to go through them. I guess we've got several questions here, James. The first one is, how does the minimum wage apply to sales people who are commissioned or base plus commission?
Great question. Remember that our law doesn't specify the forms of payment people can receive. So as far as commissions go, we won't necessarily care that a person is paid on commission, say. But for the hours that commissioned person works, their pay has to work out over a pay period to $8.55. Now, the issue there sometimes is a matter of how a commission is earned, okay? Because those rules we allow you to set on your own. So if you say you don't get a commission unless you meet these conditions, including you are continuing to work there at the time the money actually comes in, or we have checked on it and the person's check isn't going to bounce, things like that. All those conditions are fine to include as far as when a person has earned that commission. But ultimately, we're going to take a look at the stubs they got and say, for the hours they worked, divide that by, divide their pay by 855 and see if one adds up to the other. So it's, like I say, and the same thing applies for salary for that matter. If you have somebody paid on a salary that their pay doesn't work out to 855, we're going to have a problem because there is no salary exemption for minimum wage.
Next question, James. We are a tobacco-free facility. Can we have employees punch out for their 15-minute break if they must leave our property so they can smoke?
Okay, as long as the break is 15 minutes, you wouldn't be able to take any deduction from their pay to be able to do that. As long as it, excuse me, as long as it doesn't meet the 20-minute minimum we have or the federal requirements about breaks, you would have to continue to pay them during that period, even if they're off your premises. because you've designated an area for them to smoke, and they need to be able to get there. In fact, while we're on the subject, more than one workers' compensation case has come out of the fact that if it's the middle of January and they go out for their smoke and they decide they're out on the sidewalk and slip and fall in an area you've designated, then there might be some risk that follows with that as well. But I understand, certainly no smoking policies are critical, and you have every right to expect that they're not going to do that in your workplace. If nothing else, I believe there are state laws that prohibit it in many cases.
Next subject, James. An advance or loan that is agreed to by an employee to be deducted from payroll over a 3-month period that is in writing. Is that okay?
Well, absolutely. It's certainly fine to have loan agreements with your employees. The key to keep in mind is when you do that, you're no different, legally speaking, at least after the first month, than any other creditor. Okay? If the bank lends you money and you happen to be employed someplace, it's not as if the bank can come in and say, well, I'm just going to take our money for this mortgage or loan out of this person's check. They have to go through some legal steps first. So after that first month, keep in mind that, yeah, you've got a loan and you can certainly enforce it legally speaking, but there's no guarantee you'll be able to do it by taking it out of their check. By the way, I wanted to mention, I may have had it on my slide, but I missed it when I went through and discussing this. It's important for us to talk briefly about those last paycheck rules, because we get lots of questions about that. When a person is leaving your employment, either by quitting or by being terminated or discharged, you have to pay them whatever wages they have coming by the last regularly scheduled payday after the termination occurs. Now, there's only one real exception to that, and that is if they have property that belongs to you that they have as an employer that they have not returned. Doesn't matter how much that property is worth. So let's say it's a key. Key might be worth 50 cents in a hardware store, but if it opens every door in your building, it's pretty important. So we're going to say that it doesn't matter what value that property has, they have to give it back. A subsidiary question, kind of a sad state of things, that has come up in that regard is in regard to theft. Employees are actually stealing from you, and you can prove it. You have to pay them their last check because they ripped you off. And looking at that particular law, we would say, no, wait a minute. This is property that belonged to you that was taken, has not been returned. Do I have to pay this person by their next check? No. Our position is that if you can clearly establish there was theft going on, you don't have to do that because they've taken something that belongs to you. And the flip side of that, unfortunately, is that it doesn't matter what value that has when they return it. So let's say that they have a company T-shirt, okay, and the T-shirt has slashes through it and it's covered with grease, and you can't even recognize the company name on the shirt, but they gave it back. If that's the case, doesn't matter what the value of the property is, you have to give them their last check. And then you turn around, as we've discussed, and say, I'm going to collect this from you in the courts if necessary, if it's important enough to me, after the fact. So same thing goes for the loan. If I've got 2 months of loan they haven't paid up, and I want to be able to collect it, I go through the same process any other creditor does, file a suit, small claims, take them, get the money, get the garnishment, and follow through.
Great information, James. Next question, can employers have employees pay for errors in transaction? For example, gave a customer a product, didn't collect for it, or collected the wrong amount?
Again, that goes back to our rule we talked about concerning deductions from pay. And if the deduction for those kinds of errors leaves the person at $8.55 and above, we'll allow it. You've announced this policy ahead of time. The employee knows straight up what's expected. And as long as you haven't violated the minimum wage law, you're allowed to do it. The same thing applies to all kinds of things, from till shortages to, let's say, damaged property or equipment, various things that you expect an employee to be at least partially responsible for. You do that, you keep them at $8.55 and above, we're going to allow it.
Okay. Are lunch breaks required for a non-physically demanding position? If we have a retail position, there is time for them to eat, drink during quiet times.
Probably the simplest response to that is our law does not require a break of any kind. Now, you may be accommodating some individuals based on a disability that they have, as long as they're able to perform the essential functions of their job. If they need, I'll say, a minute to get that sugar for being a diabetic, or they need to take some medication for a minute or two. And I guess there's also the matter of providing lactation breaks for people that are covered by the Affordable Care Act. But generally speaking, if you're talking about breaks, they aren't allowed any. It always fascinates me. In fact, people call every day and they say, well, don't we get a break every 4 hours or every 2 hours or 6 hours? I always heard that. And our response is always, wow. No, technically an employer can work you 24 hours a day, 7 days a week, 365 days a year without a break. They won't be very happy when they do it, but you can do it.
Okay, next question. I thought that if the federal law is more restrictive than state law, then federal has to be followed, or vice versa. For example, youth hours, you indicated the state is 10 p.m., but the Fed is 9 p.m. Can you clarify that?
Yes, whenever, and federal law also speaks to that to some extent. And essentially our rule is whatever is the more restrictive standard is the one you use. So if you are subject to federal law, and just to kind of back up a minute to give you an idea of who that includes, people who are subject to federal law are businesses that gross at least $500,000 a year or engage in some kind of regular interstate commerce. For example, they openly solicit people from out of state to be their customers, or they receive federal grants of some kind. Now, that's the reason why all government agencies are subject to this stuff, because they all get federal money of one brand or another. But if you're a federal contractee, if you get that $500,000 a year gross, or you're engaged in interstate commerce, or your people are engaged in interstate commerce type activity, you're asking them to solicit out-of-state people, for example, all the time. Those people are subject to federal law. And if it's federal law that's involved and it's more restrictive than the state, or vice versa, use the more restrictive rule in whatever you do.
And James, one of our next questions was just that, does federal law supersede South Dakota law? So I think you've addressed that.
Yeah, only if it's more restrictive.
If my employer sends me to get a part and I am hourly, should I be compensated for the mileage reimbursement? I'm going to assume that this is an employer asking if that particular scenario were to arise.
Yep, that is not covered by the minimum wage law per se. And therefore we would not require it in essence as far as the expense goes. But there is a general provision in the employment law that says an employer shall in all cases indemnify an employee for quote-unquote losses that are caused by the performance of their everyday duties. Okay? So if a person is required to undertake some kind of expense in order to be able to do what is required of them, ordinarily the rule is the employer is to compensate them for it. There's no fixed rate for that as far as we can tell. It's more of a fair market value. But the employer is to indemnify the employee for those losses. And that applies to things like, gee, I have to have a uniform in order to work here. I have to undergo certain tests once I'm employed there in order to be able to work here. If you make it a condition of employment, those costs have to be covered.
James, if I have a 16-year-old homeschooler that wants to work 40 hours a week, can they?
No question.
Say again, James.
No question. They can, yes.
Okay.
Because they're already, once they're 16 and above, they're treated like an adult. And there's no limitations or anything.
What is the recommendation amount for paid time off hours used for an exempt employee not working a full day?
Well, there isn't anything, of course, specified in state law. The only issue you might have is in terms of whether the feds accept those hours in an included plan, okay? So it might be something that you want to consult with the federal office about to see if they have rules in that regard. I'm not aware of any, but it could be that they have, that they set rule parameters on how much latitude you're allowed in that regard.
Is annual leave and sick leave covered by wage and hour, or is it open to the employer to govern?
Employer decides. Wage law is not, does not delve into benefits at all. You don't have to give a person a benefit. You don't have to give them vacation time, sick leave, whatever. And you can set whatever, and at least under state law, you can set whatever parameters you wish on how that leave will work. What you giveth, you taketh away, and vice versa.
For the new salary requirements, how is a salary plus commission employee affected?
Well, the only category of people that, as I understand, that would apply to potentially would be for quote-unquote outside salespeople. That's an absolute exemption, because if a person is predominantly engaged in outside sales, they're not covered by these laws at all. So the $455, $920 test, they don't apply to these guys. All that matters is whether it's an outside salesperson or not. Now, if they're inside, you might have a different ballgame. If you've got somebody who, say, is a chief administrator in a business and they also do commission sales on the side, what the feds are going to do in that case is to take a look at what the primary duty for this person is. Are they an administrator or a salesman? Okay? If they are predominantly a salesperson, they're not going to be subject to these white-collar exemptions at all. If their primary duty is an administrative person, then you have to follow the usual rules about getting to that, at whatever threshold is going to be, 455 now, probably 970 later. Salary.
If a server works overtime, do you have to consider their total tips to calculate their overtime rates?
What they do with tips is to well, I guess probably the simplest way for me to put it is you don't change what the tip credit is no matter what tips they get. Okay, so if the tip credit, for example, for federal purposes is right now their minimum wage is $7.25. The tip wage they're going to use is say $2.12. Okay, so the tip credit is going to be $5.13. Doesn't matter how many tips they get, you're still going to end up with $5.13 as a tip credit. When you're figuring their overtime, you're figuring whatever hours they have, you're figuring time and a half for hours over 40, and whatever difference there is between that tip credit of, say, $5.13 and whatever you're paying them has to be used in figuring their overtime. So you're not going to be able to adjust it to say, well, because the person got $10 that hour in tips, that suddenly you get a credit for the whole $10. You don't. You're stuck with that $5 or whatever it is. And just to be clear, let's say that federal minimum wage is $7.25. Your starting tip credit starts them at $4.50. Okay, so the actual tip credit you're applying is say $2.75. You don't get to change that either. Your tip credit stays at $2.75 an hour, no matter how much in tips they make.
James, are owners exempt from minimum wage?
Yes, because they're not employees, they're employers. Now, there might be a difference if a business is incorporated, because as an incorporation, typically any person who performs services for the corporation can be considered an employee. Okay, so there may be times in which when you're talking about an incorporated business, everybody plays, so to speak.
James, I think our next question here pertains to the proposed overtime rule. I'll try to explain this. If I am salaried at 50 hours per week, my gross pay period is 1,346. We get paid every 2 weeks. I am on call 24 hours a day. I am curious as to if anything will change for me.
Now keep in mind, first of all, that there's a difference under the federal practice and ours between being on call and being on duty. Okay, so let's say you've got a beeper and you're you're walking around, you're in the movie theater, and your beeper goes off. Okay, until the beeper goes off, you're not on the clock for overtime purposes or anything else. So people say if they're on call 24 hours a day, well, yeah, they have to be available, but as long as they aren't on duty that whole 24 hours, that extra time doesn't matter. Okay, so we would have to take a look first of all and figure, did that person actually work, including on-duty time, for more than 40 hours a week during that 2-week period? Okay, and it may not change anything then. If we're looking at somebody who, as a threshold, has to, let's say, let's use 970 as a target. Okay, $970 a week. Well, I guess straight out of the chute, now that you look at the math, the on-call, on-duty discussion really doesn't make any difference, because they would have to have made, what, $1,940 at a minimum over that 2 weeks not to be exempt, or not to be paid overtime under that scenario. So yeah, I guess a person making $1,346 over a 2-week period is not going to meet the salary threshold under the new rules. Under the old one, clearly. Under the new one, no.
Can an employer require an employee to clock out if they leave the premises to run a personal errand that is less than 30 minutes?
Well, it's going to be, if it's a lunch break and it's less than 30 minutes, but I guess keep the big picture in mind there too. I mean, you may not be able to clock them out, but even if you did, okay, as long as that pay over that work week or pay period still works out to 7.25 for the feds, 8.55 for us, you're okay. Now, the only people then have to worry about those little trips outside, so to speak, are the ones whose hourly pay comes pretty close to the 7.25, 8.55 thresholds. Otherwise, half an hour one way or the other shouldn't make much difference.
Do we need to pay for breaks for breastfeeding that are longer than 20 minutes?
Well, you have to make that time available. The federal law, as I understand it, but that only applies, generally speaking, for employers that have at least 50 employees. Okay, but when you're talking about breastfeeding, they're not worried so much about whether the person gets paid time for that. They're more concerned about whether they get the break in the first place. Okay, so there's not a requirement, as I understand it, that they are provided a paid break of more than 30 minutes for that, or either 20 or 30 minutes for that sort of thing.
We have a lot of hourly employees who skip lunch on a daily basis. Are we okay with letting them do that?
If you're paying them for that skipped lunch, you're fine. If you're not, as often happens, we have many employers who say we're going to enforce a break where you're not paid for that half hour. If you happen to show up, well, nothing's going to change. That's a bad idea. That goes back to our rule saying if you have a rule, you need to enforce it.
We have employees that are continuously clocking in early from their 30-minute lunch, just by a couple of minutes every time. How much of a stickler is the 30-minute rule?
You have to get nasty. Okay, the feds have made it very clear that when it comes to calculating time, if you're allowing 2 minutes here, 2 minutes there, and it's consistent, you're probably going to get stuck with that time over the long haul. Okay, so you do have to get tough. You have to say, what, your break was 30 minutes. If you're making it, if you're showing up 2 minutes early, there's going to be a problem, and you have to get tough.
We pay our salesmen an hourly wage in excess of the minimum wage, and if they work overtime, we pay them time and a half. Once we calculate their commission at the end of the year, do we recalculate additional overtime due because their regular rate has increased?
Well, that's strictly based on a work week to work week calculation, as I understand it. So you might want to consult with the feds on that one, but as I understand it, they're not going to require an adjustment like that over a longer calendar period. They're strictly looking work week to work week.
All right, let's go on next one here. If voluntary benefit deductions that employee owes the company for an unpaid leave, should there be an agreement that the company is deducting a certain amount that the employee is required to pay back to the company that the employee signs?
Well, I've always been, maybe just because I'm a lawyer, but I've always been a firm believer that if you want disputes with your employees to be resolved as much as possible, get everything down on paper and have them sign it. So everything goes in straight up. They may not know everything they're signing, but at least they have the opportunity to read it and get it, okay? So I would always, always encourage you to have something in writing concerning something as complicated as that.
I wanted to go back real quick, if I could, James, to the question on breastfeeding. Answers to frequently asked questions from the U.S. Department of Labor Wage and Hour Division on this subject can be found at www.dol.gov/WHD/nursing mothers. And let me repeat that again. It's www.dol.gov/WHD/nursing mothers. And you'll be able to find some of those frequently asked questions of how the U.S. Department of Labor treats that particular issue.
Yeah, thanks for that, Sean. I'd echo the fact that if I want a lot of answers on what the feds are doing in particular areas, their site is usually pretty good about giving me the basics on almost anything. So I encourage our listeners to make use of it as much as they can.
Coming back to the minimum wage requirement as it pertains to a commissioned salesperson, it was stated that as long as the period of pay equals the minimum wage, it is okay. What period of time is used in this? A work week, annually, or pay period?
For the feds' purposes, it's the work week. Each individual work week stands on its own, okay? As far as state law is concerned, we have developed by policy that we go by pay period because the law doesn't specify. Now, you could say that if there is no pay period, we go by the month because state law requires pay to be paid by the month at a minimum.
Let's see here. Getting lots of questions, so just trying to keep them all straight. Bear with me here, folks. We allow 2 15-minute breaks per day. Can we require employees to stay in the building? Some of them go sit in their cars.
The general rule that we haven't really touched on much today is that you as an employer can pretty much set employment conditions as you see fit. So if you decide that you want to have people take a break in the building, you're entitled to do it. Just keep in mind that if you do that, you don't want them actually doing anything during the break. They are completely relieved of any duties they're required to perform otherwise.
James, can you review one more time the travel and how to pay hourly staff?
Sure. Here we go. For hourlies, consider any time that they're actually driving in the vehicle and on a employer's mandatory trip to be work time. Okay, they're always on the clock. Okay. If they're a passenger, then they only get paid if they're during regular business hours. So if your business day runs from 8 to 5, the travel is only paid from 8 to 5 as a passenger. After all, you aren't paying people to sit in the car. Now, keep in mind that the definition of work is much more flexible now than it used to be. After all, if I'm sitting in that car and I've got a laptop in my hand doing spreadsheets, I'm on the clock. I'm doing work for my employer. So it has to be a complete relief from duties while I'm that passenger. Now, as far as commuting time goes, I'm going to work. That's never on the clock, okay, unless if in a situation where I commute, say, to some designated location, and then I go from that designated location to the job site. But if I'm doing that, I'm on the clock between the office and the job site.
Does unused vacation time payable to an employee need to be paid in the next payroll after termination? Our company allows payment for accrued vacation time.
There's no state law that dictates that. The wage law, for example, that requires you have to pay all wages by the next regularly scheduled payday does not apply to benefits of any kind. So when you pay, it's up to you. It might be worth taking a look at the written policies you have on vacation time to see how that's supposed to work and make sure it's clear.
James, this question asks, I work for a religious nonprofit, so are they exempt from these laws?
In a word, no. The only context in which there might be something worth considering, and that's true of all employers, not just nonprofits, is that there are a great many people who work for nonprofits as volunteers. They agree ahead of time not to accept any pay for whatever they're doing. If that's the case, our position has been that the minimum wage law, any employment law, doesn't apply to them because they're not engaged in a contract for pay.
James, the next question is about the last check. Is it okay to deduct insurance premiums for the month if they quit or are terminated prior to the end of the month, and the insurance coverage is through the end of the month? Is it okay for that employee to end up with a zero net check?
In our view, that's appropriate. Yep.
If I am working in a hostile work environment, who can I get a hold of to open up a case? There is verbal abuse, and I have tried talking to the owner, and he does nothing. He just looks at you with a blank stare and does nothing about it.
Okay. Keep in mind that the definition of hostile work environment is limited to a very narrow set of things. One has to be discriminated against in employment on the basis of race, color, creed, religion, national origin, ancestry, sex, or disability. And if you're covered by federal law, which would be in a business that has 20 or more employees, also covers age. Okay? So the hostile work environment not only has to be pretty severe, but it also has to be based on your membership in one of those classes. So many times I get calls from people saying, my boss just doesn't like me. He says vulgar things to me. He's mean or whatever. Can I do anything about that? And I ask them, is that the way he treats everybody? And the employee says, yeah. And my response is, well, then the behavior towards you is not based on your membership in that class, so you're probably not covered by the law. But assuming that we have someone like that, what you're able to do is to file an intake form with our Human Rights Division. Our investigator in that office, his name is Ray Falk. His contact information is available in the last slide on our presentation today. Whoop, not that one. Uh-oh. Here we go. I knew I'd do that. One more time. Yeah, I almost had it perfect. In any case, yes, you would contact Ray Falk and provide him an intake form, which is available on our website, and communicate to them that that there's been this behavior that's occurred. You can investigate it and see what needs to be done.
All right, James, we're going to try to wrap this up here in the next 5 minutes. We've got a few more questions asked and some that we may not be able to get to, and so you've got your contact information up, and we'd encourage anybody if they want to follow up by contacting James or his staff. Feel free to as the email address on your screen. On the comment about deductions for kill shortages, losses, or etc., over what time frame do you use to figure the minimum wage? 40 hours or a work week?
For federal purposes, it's the work week. For state purposes, it's the pay period.
Do new fathers get time off for the new baby? We're going to try to rapid fire in some of these here, James.
Okay. As I understand it, well, this is not something that we regulate, but in cases where they are subject to the Family Medical Leave Act, my understanding is that fathers have the same status as mothers. But that's something you would need to take up with the United States Department of Labor since they regulate that area.
If you pay bonuses, do the deduction rules apply if the employee has kill shortages? Can the shortage be withheld from the bonus?
Yes. As long as the person ends up total with at least 855.
Next question. If you have a location in another state, do you follow their state laws, or can we follow the South Dakota laws since it's a South Dakota business?
For employees that are located here, follow South Dakota's rules. If their employees are located elsewhere, you follow those rules. That can be a little tricky from time to time because people are so transient these days in terms of their work responsibilities. But as a general rule, the area where they spend the primary amount of their time, the predominant amount of their time, is the one that dictates what rules are followed for that employee.
James, clarifying returning property when an employee is ending employment. If they do not return a key, I never have to give them their final check. Question. We wait until they return it, or if they don't, do we retain the check?
Our position has been that you never have to pay the employee that final check if the property has not been returned. Now, the feds may have a slightly different view about that, but suffice to say, under state law, it's an absolute rule. No property, no check. In fact, after a certain period of time, I believe about a year, if the wage has never been claimed, it would probably be turned over to the state treasurer's office in their unclaimed property section.
Okay. If an employee is given a week of vacation every year and quits mid-year, is it okay to just pay out half that time if they haven't used it, or do you have to pay all of it out?
And we're referring to vacation time there? Okay, yeah,
that's
fairly up to employer policy. You know, how they apply vacation time. It's in essence a gratuity. So the employer can choose how to handle those situations. It also came to mind to me when it came about the matter of the deduction for pay, or rather the last paycheck and not paying it. Important that the employee, it's fairly sure they actually have the property you're looking for. If they have a key, you need to know they got it. If they come back and they say, I lost the key, and it's legit, we're going to say go ahead and pay them the check because they no longer have the property they're looking for.
If an employee is classified as a salaried employee but the duties are not white collar that you reference, then should that employee be an hourly employee and subject to overtime pay?
I would recommend that, unless the employee falls into the second class of exemptions, which are miscellaneous. Probably the easiest thing to do is to look those up on the federal website to see. There's a cheat sheet that you can use. I guess I don't list it in these slides, but there's a generic list of things from breaking ships to working at a radio station to being a newspaper carrier, things like that. If they fit in one of those kind of generalized categories of work, even if they get paid less than the minimum wage or less, they aren't subject to overtime anyway. But generally speaking, if you have somebody who doesn't fit in one of those white-collar exemptions and they're not on the miscellaneous exemption list, you should really pay them by the hour instead of on salary, because it's just not smart to pay those kind of people on a salary basis.
Yeah, and I would just mention here again real quick on those questions specific to the Federal Department of Labor, that website is again www.dol.gov/WHD. For example, in the case of overtime, there's a section specific to that right there. So then I would qualify for overtime pay on the 10 hours over 40, even if I am salaried.
Yes.
Hourly employees who run an errand on the way to lunch, do we have to pay them for the time that they spent doing our errand?
Our view is that time is included in the time figured for their minimum wage. A secondary issue worth considering is that it fits under what's called the dual purpose doctrine under workers' compensation purposes. So if the person rolls the car on the way to doing the errand for you, they're also covered by workers' compensation coverage.
And just real quickly, let me go back on that U.S. Department of Labor. The fact sheets on the various federal wage and hour issues is again www.dol.gov/WHD/facts-sheets-index.htm. Does an outside salesperson refer to those that are on the road all the time, or can it be a combination of road sales and office sales?
The test that's applied is whether they predominantly engage in outside sales. So, and a rule of thumb we've used is to say it has to be at 50% plus. So if 50% plus of their time is spent outside the office doing sales on the road, they qualify. But it can be a mix.
Do we have to pay employees if they need to leave work to vote?
No. The state will pay them. The only thing you can't do is to prohibit them from going to vote. That's the only thing state law prescribes.
Yeah, and under state law, employers must provide up to 2 hours of paid time off for employees to vote unless polls are open 2 consecutive hours of the employee's non-working hours. If the polls aren't open for the 2 consecutive hours during employee's non-working hours, the law allows the employer to specify the hours during which the employee may leave work to vote. And let me also give you folks the phone number for federal labor law questions. You can call the Denver office of the U.S. Department of Labor, which includes our region. That phone number is 866-487-9243. Again, that's 866-487-9243. James, we're going to take 2 more questions here, and then we'll wrap it up. And again, if you can go back to that contact information, if folks want to send you an email directly, we'd be happy to do that. Just going back to the question about a non-exempt employee leaving the premises to run a personal errand, such as taking their children somewhere, and the employee returns in less than 30 minutes but left the premises, can we require them to clock out?
And it's less than 30 minutes? Like I say, our threshold for breaks as far as state interpretation goes is 20. So if their break is, I'll just to try to make it clear, more than 20, less than 30, okay, but it's not a lunch break. Our view would be that you could clock them out for that time because they're engaged in a purely private manner. But the earlier question talked about the fact we did a private matter and the employer's business at the same time. In that case, it's all going to be on a clock. It's not a break at all.
James, can you pay a lower wage per hour during drive time? For example, an hourly employee who makes $15 an hour, can you pay them the minimum wage while they are driving?
Yes.
Okay. I know we've got a few more questions left. We're also running short on time, and we promised folks that we try to keep this to about an hour. We're at about an hour and getting close to 20 minutes. I want to thank you, James. Just incredible information as always. I always appreciate the amount of time and thought that you put into answering these questions. And as I said at the beginning, James and his folks are a tremendous resource to our association. I would encourage any of you to feel free to contact him at any time. James, do you have any any closing comments or thoughts?
No, I think it's been great. I certainly appreciate the opportunity.
And again, in the fall, our organization will have our annual labor seminars with Jackson Lewis. We'll be announcing those dates here very shortly. I would encourage anybody to consider attending those. We have several other webinars scheduled, and actually before I get to that, I want to remind everyone that this webinar was recorded, and a link to the recording will be emailed to all of you later today. As I mentioned, we have several other webinars scheduled. Our next one is coming up on April 28th. Chris Hoyme of Jackson Lewis Law Firm will explain the proposed changes to the federal overtime rules. That webinar is available exclusively for SDRA members. You can check out our website for details at www.sdra.org, and under the training tab, click on webinars and seminars. James, again, one more time, thank you so very much for your time today, and I want to thank everyone for participating in today's program. With that, we hope you have a great day. Thank you.
Thanks.